When employers get sued for misclassifying employees as exempt from the Fair Labor Standards Act, the burden of proof is on them to prove that the employee are exempt in the first place. A recent Fourth Circuit case called Carrera versus EMD Sales shed some light on the controversy on the burden of proof for the employer. 3 former employees sued EMD Sales for misclassifying them as exempt from the Fair Labor Standards Act and sued to collect for unpaid overtime. The case went to trial. It took 9 days, and the plaintiffs ultimately won, and the court awarded them back overtime and liquidated damages. On appeal, the employer argued that the trial court made a mistake because they're making employers prove that employees are exempt under the FLSA using a clear and convincing burden of proof. The employer wanted the Fourth Circuit to adopt a lower standard that is used in the Fifth Circuit, the Seventh Circuit, and the 10th Circuit Court of Appeals, which recognize preponderance of the evidence, because if you have to prove clear and convincing, not only do you have to have evidence, but you have to provide convincing evidence. The Fourth Circuit Court of Appeal ruled against the employer. The Fourth Circuit Court of Appeal recognized that their burden of proof may be different from other circuits, and they may revisit that in the future, but not for this case. Now, this case is ripe for appeal because when you have a split in federal circuit on what the burden of proof should be, the U.S. Supreme Court would be the next stop. The U.S. Supreme Court could rule that it is the clear and convincing burden of proof, or the lower threshold preponderance of the evidence. So we'll just have to wait and see. Okay, back to work.